Doing well. It is a windy Kansas day today. If anyone had any fears of coronavirus particles lasting long in Kansas, I think today's not a worry. They are blowing out of the state at about 20 miles per hour. Today we have two topics to cover. One is something that I wrote in my recent Breitbart column about last week, and the other is something that is of very recent vintage, and that, of course, is the governor's latest emergency declaration. So we'll call this one Activist Courts and Imperialist Governors. But I want to start with the court decision out of the 10th Circuit U.S. Court of Appeals. This was just last week. And for those of you who aren't familiar with it, you can go to Breitbart.com and then go to the search box and then type Kobach 10th Circuit. You can get my latest opinion on this. I'm going to talk about that right now. The 10th Circuit just did something that is extremely bad for the United States. The 10th Circuit is, of course, the U.S. Court of Appeals that covers Kansas. It also covers Oklahoma, Colorado, Utah, Wyoming. I don't think I got all, and New Mexico. Anyway, I used to clerk on the U.S. Court of Appeals for the 10th Circuit. That was my job right out of law school. Clerkships on courts of appeals or the Supreme Court are obviously a plum that law students try to get, and I was fortunate enough to have that opportunity. Back when I clerked on the U.S. Court of Appeals for the 10th Circuit, it was a conservative circuit. The majority of judges were appointed by Republican presidents. The majority of judges were constitutional originalists. Unfortunately, the passage of time in the last quarter century has turned the 10th Circuit into a very liberal court, or at least a liberal-leaning court. We now have a situation where the majority of judges on the 10th Circuit are appointed by Obama or Clinton, and several of the Republican judges, including a judge who authored this opinion that I'm about to talk about, are activist judges that slipped through the cracks in the Bush White House. Had President Bush known their true colors, I don't think he would have appointed them. But it just shows how important the Senate is in being that last bulwark against the appointment of activist judges. So anyway, the 10th Circuit is now a court that looks, frankly, more like the 9th Circuit than it looks like a conservative circuit. A conservative circuit would be the 8th Circuit, which includes Missouri, the Dakotas, Iowa, Minnesota, Arkansas. That's a conservative circuit. The 5th Circuit is also conservative. That includes Texas, Louisiana. The 11th Circuit, which includes Florida, Alabama, also a conservative circuit. But the 10th Circuit, unfortunately, is a liberal-leaning circuit that looks many times much more like the 9th Circuit. And today, it looks a lot like the 9th Circuit. So what am I talking about? Well, as you may recall, when I was elected Secretary of State in 2010, I promised to bring about photo ID laws to Kansas elections, and I promised to bring about other reforms that would stop voter fraud, chief among them proof of citizenship. And so I drafted a bill that made Kansas the toughest state in America to commit voter fraud in. And that bill included photo ID as well as a requirement that people prove citizenship at the time of registration. There are only 4 states that have proof of citizenship. Georgia, Alabama, and Arizona are the other 3, and I helped Alabama draft their proof of citizenship law. Anyway, fast forward. So the 2011, the legislature passes it with overwhelming majorities. I think every Republican but one voted in favor of it, and 2/3 of the Democrats, more than 2/3 of the Democrats in the Kansas legislature voted in favor of it. That was before they got the memo from Bill Clinton that they're supposed to be against proof of citizenship, against photo ID, but that's another story. Anyway, the ACLU sues, of course, as we knew they would, and the case goes up. And we now have the decision, the appeals court decision out of the 10th Circuit. The decision was rendered by 2 judges rather than 3, because one of the judges, a senior judge, I believe it was McKay, passed away after the case was already appealed to those 3 judges. And so the 2 remaining judges were one was a Clinton-appointed activist judge, and the other was this Bush-appointed activist judge who slipped through the cracks. And so it was not a surprise that the court ruled against Kansas's proof of citizenship law. But I want to point out to you just how outrageously bad this decision is. I'm very hopeful that Attorney General Schmidt will appeal this decision to the United States Supreme Court, and I am certain that if the United States Supreme Court takes the case, that it will definitely be a case where they overturn what the Kansas court did. So let's look at the decision. The case was Fish versus Schwab. It was originally titled Fish versus Kobach, but then when I left the office of Secretary of State, Scott Schwab took over as the named plaintiff. In this case, the ACLU challenged our proof of citizenship law in Kansas, which has been fantastically popular. We polled the popularity of the law. Kansans overwhelmingly liked it, found it easy to comply with. And they said that it violated the National Voter Registration Act of 1993 and that it violated the Equal Protection Clause of the U.S. Constitution. Yes, you heard me right, that somehow it would violate the Equal Protection Clause of the U.S. Constitution. These were laughable arguments, and in front of any judge who reads the plain meaning of statutes and sticks to the original understanding of the Constitution, they would have gone nowhere. But unfortunately, in front of activist judges, they went somewhere. And so this is what the court issued in its 2-0 opinion, striking down the Kansas proof of citizenship law. First of all, let's look at how the law operates or operated. And many of you Kansas voters are personally familiar with it. You know, it was no trouble at all to comply with. Basically, everybody who was already registered to vote at the time the law came into pass in 2011 was grandfathered in. So you didn't need to reprove your citizenship or prove your citizenship for the first time. But ever since that point when the law took effect, and actually the effective date was after that. It was, I believe, in 2012 or 13. But be that as it may, after the law took effect, when you registered, you had 90 days to prove your citizenship. You could prove your citizenship at that time, and you could do it with a passport, a birth certificate, military document, State Department document, a whole bunch of documents would suffice. Or the state would prove your citizenship for you. If you were born in Kansas, we could track that down and verify your citizenship. Or if you had a Kansas driver's license and had already proven your citizenship because you wanted a TSA-approved driver's license that will allow you to fly on flights after a date coming up here, then we would have your birth certificate in the driver's license database. So anyway, very easy to comply with. We had 90 days. So a lot of Kansans went on this list, which was called the suspense list, of people who had registered to vote but not yet proven citizenship. The vast majority of them, about 95% of them, went off the list. In other words, their citizenship was eventually proved. The remaining 4 or 5%, probably not citizens, because it was so easy, if you were a citizen, to prove you're a citizen. And the law was accomplishing its effect. But of course, the ACLU sued and falsely argued that anybody who was ever on the suspense list because they had sent in their form but not yet proven their citizenship, they were being disenfranchised. Not at all. They were just in the middle of the process. But the 10th Circuit repeated that false statement that these individuals were disenfranchised. And that was just the beginning of the errors that the 10th Circuit made. Looking at the statutory challenge, the claim that Kansas's law requiring proof of citizenship somehow violated the National Voter Registration Act, or the Motor Voter Law of 1993, they really had to stretch, because there's nothing in the Motor Voter Law that says anything about proof of citizenship. And in fact, the question was asked of Wendell Ford, Democrat of Kentucky, who sponsored the bill in the United States Senate. The question was asked on the United States Senate floor: does this bill do anything to restrict a state's ability to require proof of citizenship? And Ford said this, I have the exact quote: "There is nothing in the bill now that would preclude the states requiring presentation of documentary evidence of citizenship." End quote. Well, so much for the intent of Congress. That didn't seem to concern the two judges of the 10th Circuit. Instead, they concluded, they created a test of their own making and said that in order to be legal under the National Voter Registration Act, the burden of reaching into your wallet or reaching into your desk drawer and finding your proof of citizenship had to be less than the benefit of keeping aliens off the voter rolls. And so they wanted the state of Kansas to prove how many aliens they had found on the voter rolls. We gave them 127 names, but it's very, very hard to, that's only a tiny percentage of the total number, because there's nothing in the in the voter rolls that indicates a person is a non-citizen. So you have to find external evidence, and that would be perhaps the person declined jury duty and signed a form saying, I'm not a citizen, therefore I don't want to serve on the jury. That's how we found some of the aliens. Or perhaps the person applied for a Kansas driver's license that only non-citizens can get. That's how we found some of them. So the point being, we found lots of aliens, but one of the experts at the trial said it's likely in the multiple thousands of people on the voter rolls in Kansas who are not U.S. citizens. So it's a very big problem, but the court's opinion reads more like a policy paper than a judicial opinion, because that's, of course, what activist courts do. They don't look at the law and simply say, yes, the law is this and the Kansas requirement is that, and the two are comply with each other. Instead, judges decide that they act like they are legislators and they make the law change into whatever they want it to be. And that's what they did here. And they said that the Kansas requirement violates that federal law. So that was one part of the opinion. Really outrageous. It will not stand on appeal. If the Supreme Court takes it, they will reverse it. The second part of the opinion concerned the Equal Protection Clause argument. And here the argument is even worse. The argument made by the ACLU and parroted by the judges is that the Equal Protection Clause somehow stops a state from requiring proof of citizenship. Now, if you're like me, you might be scratching your head. How in the world would the Equal Protection Clause, passed in the wake of the Civil War, stop a state from requiring proof of citizenship? And of course, if you consider the original intent of the drafters and ratifiers of the 14th Amendment, you would know that they had no intention of stopping a state from requiring proof of citizenship. But again, the intent of the drafters of the Constitution was not important to these judges. Instead, they looked at a test that the Supreme Court applied in Marion County Election Board versus Crawford, which was a 2008 case where Indiana's voter ID law was challenged, and the court rejected an Equal Protection Clause challenge to that law. And the court, in that opinion, offered all kinds of great points that support the state of Kansas. In fact, when I was helping to brief the case in the district court, we cited the Marion County versus Crawford case because it was so helpful to the state of Kansas. In that opinion, the Supreme Court said that a state doesn't need to prove how much voter fraud there is or how much they've found, because stopping the threat of voter fraud is enough of a state interest. The court also said that the state has a very high, compelling interest in stopping, a very important interest in stopping non-citizens or ineligible voters from voting. So the opinion was actually very supportive of the state. But sure enough, the activist judges turned the opinion around and pretended or argued, not convincingly, that the opinion from the Supreme Court in Marion County versus Crawford hurt the state of Kansas. So that's a quick summary. There are many other things I could say about the opinion, but I know that the non-lawyers watching this might be getting a little bit bored, and maybe some of the lawyers too. But the point is, the 10th Circuit issued a very bad decision, and this decision is going to have huge consequences because other states were looking at this litigation. I know for a fact that other secretaries of state, other legislatures, and other states were looking at the Kansas case, hoping the 10th Circuit would do the obviously correct thing and say, yes, it's okay to have proof of citizenship in your election process. Now, however, that it throws that into doubt unless the Supreme Court overturns this really outrageous opinion. So I'm hopeful that the Attorney General will appeal to the Supreme Court and do so quickly. And I'm quite certain that if the Supreme Court takes the case, they will overturn what the 10th Circuit did erroneously. So that's a quick summary of something that's really big that's happened. And again, if you want to, if you're as concerned about this as I am, because it is a fact, it is a huge problem in our country that non-citizens are on the voter rolls. The numbers are in the thousands in the state of Kansas, but if you look at the entire country, the numbers are either in the hundreds of thousands or the millions, especially in states like California, and Texas, states where there are just a lot of non-citizens. And one thing should be clear, not all of them intentionally are violating the law in becoming registered to vote illegally. Many of them are doing it accidentally, in part because of the motor voter law. The motor voter law required every state in America to offer a person getting a driver's license the opportunity to register to vote. And so you have every day in America thousands of DMV clerks across the country saying at the end of the interview, "And would you like to register to vote?" And the non-citizen who's just gotten a driver's license that non-citizens are eligible to get says, oh, this nice lady at the DMV just asked me if I would like to register to vote. I guess that means I can register to vote if I want to. And so that's why so many of them, mistakenly said yes, and then not realizing what they were signed their name underneath a box that says, I am a citizen of the United States. So that's not to say that the hundreds of thousands or millions of non-citizens on the voter rolls all intended to break the law. I'm sure some did knowingly break the law. But the fact is, whether they did it intentionally or not, it's illegal for them to register to vote, and it's certainly illegal for them to vote. So this is a problem, and if the 10th Circuit decision is allowed to stand unappealed, then this problem will not be solved in the near future. So that's the first major issue of the last week that I wanted to bring to your attention. And again, you can read more about it in my column at Breitbart.com. And we will that column should already be up on my campaign website, which is KrisKobach.com. And there you can read all about my various opinions on that website, various Breitbart columns. But the second thing I wanted to talk about was the governor's new emergency declaration, or state of emergency declaration, or disaster declaration. Sorry. The problem here is that the governor has now gone beyond what the Kansas law allows. Although it is certainly good news that the governor is easing the restrictions that she was imposing upon the state of Kansas, the statute says that the governor can issue such a declaration, and then within 14 or 15 days, I forget the exact number, I don't have the statute in front of me, the legislature must ratify it for the declaration to remain in effect. And the Kansas legislature did up to the date of May 1st. But what the governor then must do is get the legislature to ratify it again if she wanted to extend it. However, what Governor Kelly did was just issue a new declaration. And clearly, the Kansas statute does not contemplate that the governor has that authority. So because she is acting beyond the scope of her legal power, the declaration that she has issued is not legally valid right now. That's not to say that people shouldn't be social distancing and that the content, some of the elements of the order aren't good advice, but to argue that it is legally binding would be a losing argument, I think, in court right now. So this is where we are. Activist judges, imperialist governors. And that's why we need some change in the United States. That's why I'm running for the United States Senate. I intend to stop activist judges from getting on the court in the first place. It's certainly not a requirement that a U.S. senator be a constitutional law professor, which I was for 15 years, or even be an attorney. But it's important that we have a number of constitutional law professors or constitutional attorneys, constitutionalist attorneys in the United States Senate, because it takes people with the knowledge of the issues, the legal background, and most importantly, the backbone to push back when a judge is offered by either a Democrat or a Republican president and say, no, this judge is not a good one. And this judge does not respect the original intent of the Constitution. President Trump has done a fabulous job picking judges. His White House counsel's office has been extremely good in vetting all of their judicial candidates. I don't know of a single mistake this White House has made in putting judges on the court. That stands in contrast to the administration of George W. Bush, which made a lot of mistakes and put a large number of activist judges on the court. I know because I have argued cases in front of those Bush-appointed judges. And that's where Republicans, they have to be able to say to the president of their own party, sir, this one's a mistake. This judge is someone you should withdraw, and you should find someone who respects the original understanding of the United States Constitution. And so I think it's important to have senators with that perspective and with that ability in the United States Senate right now. So although this decision is extremely bad news for the people of Kansas and indeed the people of the United States, this 10th Circuit decision, it does underscore one very important role of the United States Senate. It's the Senate's job to stop these judges like the ones who issue opinions like this, from getting on the court in the first place. Because once they get on, they're there for life. All right. Well, we will take some questions now. I've been going for about 20 minutes. My assistant and daughter, Molly, is here.
Okay.
Molly's in charge, wearing some very sharp camo,
Yes.
retro camo. So you got any questions for me, Molly?
Brian asks, what is the likelihood that Derek Schmidt and Scott Schwab will appeal?
I hope the likelihood is very high. I have not spoken to either of them, but I would hope that they would defend the Kansas law. Certainly, if you are a Kansas voter, you can write or call their offices and thank them for defending the law so far and encourage them to keep on defending it, encourage them to appeal to the United States Supreme Court. I would hope that they would do so, but sometimes it's nice to have a pat on the back from voters saying, hey, thanks for defending it and keep up the good work.
Okay. Kim asks, what do you think of county election clerks sending mail and ballot requests to every home?
Yeah, so that's an interesting question, and there are a variety of opinions on this. So what Kim's talking about is, at this point, the 5 largest counties in Kansas have done this. In theory, every county could. There's no law prohibiting them from it. And what it is, it's the county election office, or in the case of all of the counties except for the 4 largest, the county clerk's office, sending a card in the mail. Some of you watching this may have already received the card in the mail saying, if you would like to receive an advance ballot, a vote by mail ballot, here's your card, fill it out, return it to us, and we'll send you your ballot when the time comes. The argument for it is, well, there's several arguments for it. One is that if you increase the number of people voting by mail, then you decrease the demand for election locations. If a county knows that a large percentage have already requested mail-in ballots, the county can spend less money in the cases where money needs to be spent, renting the locations. Most counties just rely on volunteer, but some counties pay the poll workers. So that might save a little bit of money there too. That's the argument. The argument this year in the whole coronavirus situation is that getting more people to vote by mail will be safer for the people than appearing in person at the polling place. Well, we'll see. It'll depend on what the actual figures and risk is at the time, but we're already getting to a point where we can open up. And as I mentioned in a previous Facebook Live, it is certainly possible to have in-person voting that poses no risk to the voter. You can do it curbside. You can have paper ballots that are brought to the person's vehicle, and then the poll worker stands there while the person votes, and then receives the vote in a folder so that it's confidential, takes it inside. There are plenty of ways to do it so that you can maintain social distancing even inside a polling place, just like you maintain social distancing at the grocery store, just like you maintain social distancing in so many other places, at the hardware store, wherever. You can certainly do it at a polling place as well. So I understand that some of these counties may just want to make the issue lessen or go away. It won't go away, but reduce the amount of in-person voting. So I understand that. Although I don't think it's, let's put it this way. What is the objective? Is the objective to get everybody to vote by mail, or to get an extraordinary number, maybe 75% or 60% of voters to vote by mail? There are a couple of problems with voting by mail, and these are ones that everybody has to acknowledge. One is that it is inevitable, and it has been proven that a substantial percentage of ballots sent in the mail don't arrive, because as hard as our postal workers work and as well as our mail system functions, stuff gets lost in the mail, and that includes ballots. So there is a risk that if you have, let's just pick the number. I've seen different studies, different percentages, anywhere from 2% to 10% of the ballots don't make it. Let's just call it 5% for the sake of argument. If 5% of 100,000 ballots, don't make it, that's 5,000. But if you double it and now it's 200,000, well, now you're talking 10,000 ballots that may not make it. I'm not saying 5% is the accurate number. It depends on the state, depends on the Postal Service and all of that. But if you increase the number of voting by mail, you increase almost certainly the number of ballots that will be lost. Voting by mail has another risk, and fortunately in Kansas, we have mitigated that risk, and that is the risk that someone can falsely request your ballot for you. Before I became Secretary of State, nobody verified the signature. So if you were sent that notification from your county offering you the opportunity to vote by mail, and somebody else sent it back in for you, no one would check to see if your signature matched. It could be someone could just forge your signature very easily, and that was happening with some regularity in Wyandotte County, according to reports from the Wyandotte County Election Office. Before I became Secretary of State. Well, we fixed that because the law that I drafted requires now a signature verification. Your ballot won't be sent to you unless your signature matches the signature on file. The second security mechanism that I put in place in the law that the legislature adopted is virtual proof of citizenship. Virtual photo ID. You either send a photocopy of your photo ID with your mail-in ballot request form, or you write your entire Kansas driver's license number on the blank on the form, which suggests that you are probably holding your driver's license while you are writing it on the form. So it's a virtual photo ID requirement. And those two security measures reduce the risk of people falsely requesting someone else's vote by mail form. Unfortunately, I'm not aware of a single other state. There might be one, and it escapes me right now which other state has that, but at least 45 of the remaining states don't have that. And so vote by mail request forms can be a subject to that type of voter fraud. Anyway, so to the point, there are risks, and the higher you increase the percentage of ballots that are done by mail, the greater those risks.
Okay. Jack asks, how do you expect to win a statewide race, specifically in JoCo, one which was difficult for you in 2018? Will your strong immigration law message resonate
Yep.
with suburban women?
Yes. Let me grab a Diet Coke while we take a break here. So there are several elements to Jack's question. One is the fact that in the 2018 race for governor, that the Democrats did so well in the 3rd district, which is basically the KC metro area. The history of this is worth noting. First of all, governor's races for the past 56 years have alternated Republican, Democrat in the state of Kansas. And so according to that pattern, it was the Democrats' turn to win in 2018. In contrast, Senate races are very different because voters in Kansas are much more conservative on federal issues as opposed to state issues like K through 12 education. The record has been a winning streak since 1932 of Kansas Republicans U.S. Senate candidates. So the landscape is different in the two races. The other thing that happened in 2018 in Johnson County in particular was there was a wave, a blue wave that hit Johnson County. The Sharice Davids congressional campaign did an extraordinarily good job of getting voters to come to the polls who do not normally vote in non-presidential election years. In the 3rd district, normally, the Republican candidate in a non-presidential year would get about 135,000 votes. The Democrat candidate would get about 90,000 votes. But in 2018, there was a surge of an additional 80,000 voters, nearly doubling the number of Democrat votes to 170,000, which of course led to Davids beating Yoder in that 3rd district race. So what about that wave? Is that wave going to appear again in 2020? Well, we don't know for sure. But it appears that most of those extra voters were people who were already registered Democrat and just voted in presidential years before. And the Davids campaign, along with some general sentiment among Democrats after Trump's election, that caused them to vote in a non-presidential year. If that's the case, the presidential surge, every presidential year, the number of voters increases by a huge percentage. And so the Republicans will see that increase in 2020, whereas only Democrats saw that increase in 2018. So I would say that regardless of what the Republican candidate for Senate does, although the 3rd district will always be a competitive district because of the population of it, because of the higher number of Democrats there, because for a whole variety of factors, it will not be as steep a climb as it was in 2018, because the Trump voters, the Republican presidential year voters, will be showing up to the polls. However, the candidate who's running, hopefully me, will have to do an extraordinary get out the vote effort, which we've already been planning to make sure that Republican voters do remember to vote in the presidential year of 2020. The other part of the question was about my strong stance against illegal immigration. How will that affect female suburban voters in Johnson County? I believe that it affects female suburban voters in the same way it affects virtually all other Kansas voters, and that is people understand that illegal immigration presents a security threat. Sanctuary cities. We now have a sanctuary city in Johnson County, Roland Park. When you have sanctuary cities, that provides a security element for criminals who are among the illegal alien population. They're not going to get deported in sanctuary jurisdictions, and that results in a real risk to people. So illegal immigration combined with sanctuary cities threatens the safety of Johnson County families, threatens the safety of all Kansas families. And indeed, there are several sanctuary counties in addition to that sanctuary city in the state. So I believe, and the polling that I've seen reflects this, that suburban voters do realize that illegal immigration poses threats to their security, in addition to the threats to the economic well-being of workers who see their wages depressed by illegal labor. And one other point that I think needs to be mentioned now is, as we try to ramp up our economic engine, get the engine started again after this coronavirus shutdown, we have to make sure that those jobs go to Americans first. We have an extraordinary number of unemployed people in the country. Indeed, we have recession-level unemployment. It is imperative that American workers get those jobs, every job, from the blue-collar job that is the lowest-paying job to the white-collar job that is very high-paying. There are lots of Americans who will be bidding for those jobs at every level of the economic ladder. And it is essential that there is no illegal labor competing against Americans for those jobs. We have to put our people first. We have to put our country first, our countrymen first, men and women. And that's why, in addition to the security threat that I think people in Johnson County certainly recognize, there's also the economic need of our own citizens who need to be put first.
Okay. Let me get to the right part. Kris asks, is the legislature doing anything to stop the governor's newest executive order, and does the county's stay-at-home orders have any legal standing?
Kris touched on the second part of my comments. I'm not aware of the legislature doing anything right now to respond to the governor's executive order. I mean, I think there certainly is room for litigation at this point, because, as I mentioned, the current executive order of the governor is on very weak standing, very thin ice right now, since it appears that she is going against both the letter and the spirit of Kansas law by reissuing a new executive order, a new declaration, rather than having the legislature have the legislature ratify or approve it as the law indicates should be done. So and then the second part of the question was the counties. I wish I could give a more precise answer, but it depends. Different counties have different county charters and different ordinances in place that allow counties to do interim measures that might suspend activity. But I would say that in many instances, skepticism is in order, because most counties do not have authority on the books for the county commission to simply say, we demand people stay at home. So, there was authority in the governor's, in the Kansas statute that the governor relied upon at first, but there's not authority now for what the governor's doing. And that statute does not give the counties authority to do something, even more extreme than the governor might do or might be wishing to do. And remember also that Governor Kelly's order was already declared potentially unconstitutional. I say potentially, as a temporary restraining order. She lost in court already on a temporary restraining order ruling in federal district court from Judge Brooms, an excellent opinion, which we've talked about here on these Facebook Lives. So, these orders are becoming less and less legally sound as time goes on. I think, as I say, the governor's current order is legally problematic under Kansas law. All of her orders with respect to her previous order with respect to churches was unconstitutional, as the court already found tentatively in a TRO setting. So there are a lot of problems with these various orders. So they should be viewed with skepticism. That is to say, just because a county does something or just because the governor does something does not mean that government entity has the legal authority to be doing it. Setting aside the question of whether it's good advice, it might be great advice, but whether you can force someone to follow that advice is a question of law.
Okay. The next question. Susan asks, can AG Barr step in and do something about Kelly's state of disaster emergency orders?
The reason I'm pausing on that one is so the U.S. Attorney General could step in only if her order were violating federal law. So, for example, in the case of the churches who successfully sued the governor, the two churches, the one in Junction City and the one in Dottie, there the Attorney General could step in because the Attorney General could say accurately, this is a violation of the church's First Amendment rights. The Justice Department has the authority to act to enforce civil rights. And so either the Justice Department could have brought an action on its own or the Justice Department could weigh in on behalf of the churches. If there were a similar case or another case that involved a federal civil right, so someone asserting rights under the Constitution of the United States, then yes, Attorney General Barr could either bring the action or assist or intervene or come in as an amicus party, which means amicus curiae, friend of the court party. So I'm just thinking out loud here, hypothetically, if you had a political organization suing the governor, saying that her current authority, her current order violates that organization's ability to assemble to petition the government for redress of grievances under the First Amendment, and also that it's unlawful under Kansas law, bring a two-part claim, then it would be possible for the Justice Department to assist in some way in the ways I mentioned. So it depends on the question of whether there's a federal statute or a federal constitutional provision at issue. If there is, then yes, the U.S. Justice Department can get involved.
Okay. Scott asks, do you support ethanol and or the constitutional of renewable fuel standard? Or is it continually?
Continuation. Yeah. Do you support ethanol and or the continuation of renewable fuel standards? Well, I guess there's really two questions there. Do I support ethanol? Yes. I think, ethanol production is a significant part of the Kansas economy, and ethanol plays a valuable role in the multiple fuels, the multiple energy sources that we have for our vehicles and more broadly for our economy. So yeah, absolutely support the Kansas ethanol industry. Do I, however, support the continuation of the renewable fuels standards? I don't think that the federal government should be mandating a percentage of the whether you're talking about power generation for homes and industries or power generation for vehicles. I don't think it's the government's role to mandate what percentage is generated through renewable fuels versus others. Just like I oppose the Sebelius rule on the percentage of power that Kansas homes have to receive or Kansas power companies have to generate from renewable sources. I don't think that is productive. It resulted in more costly electricity. That's why Kansas, by the way, has higher electricity rates than any of the four states surrounding us. If you compare it, especially with Oklahoma, Kansas has far higher electricity costs. I mean, the difference is dramatic. And one of the reasons is the imposition of these standards by the state government. So generally, I don't think the government should intervene in the marketplace like that. To force an arbitrary number or an arbitrary percentage upon the public.
Okay. EJ asked me if I'm going to follow your footsteps and become a lawyer.
That must be EJ Irish. EJ, good to hear from you. I don't know. I guess that question is you, Molly.
I don't know. It just really depends on what God planned for me.
Well, that's a good way to put it. What do you think right now? Do you think you might become a lawyer?
I don't know.
You don't know?
Nope.
Do you have a top 3 list that you want to share with everybody of
I
things you
would-
might want to do?
I want to either become an ornithologist, an endocrinologist, or I don't know.
Or maybe a lawyer?
Maybe, I don't know.
Oh man, I'm having to push for it, EJ. So yeah, there's an interesting 10-year-old for you, ornithologist or endocrinologist. Molly, like me, is a type 1 diabetic. That's the interest, I assume, in endocrinology. And Molly is an avid bird watcher. And in fact, if you haven't seen it, somewhere on this Facebook page, or certainly on my campaign page, there should be a video that Molly and I did calling in barred owls. So Molly's pretty skilled at some of that fun stuff. Okay.
Dennis asks, Kris, would you support making a provisions of Executive Order 2020 permanent, allowing notarization
Notarization of audio and visual communications.
Scanning the document, emailing it to the notary rather than notarization only by meeting in person?
Portions of it. I do think that there's a reason we have, notarization requirements, and that is that you actually observe that, the whole point of a notary public, right, is the notary is there to certify that if Molly's the notary and I'm signing some important document, Molly is certifying that yes, Kris is signing this document and I have witnessed the signing of that document. So I don't think we should go entirely to a virtual notary system. So I wouldn't support doing that. But I do think that there are many documents that can have, that are certainly less important documents. Say, on the category of document importance, maybe a will would be at the highest, right? You actually want to have a person witnessing that the individual is committing his or her resources in this will in this manner. But there are many documents that are less, I don't want to say less important, but I'll say it, they're less important than that. And you can have a virtual notarization. You can have a series of electronic measures to ensure that it almost certainly is the right person signing. I'm sure many of you have signed electronic signatures are becoming very, very common now. And virtual notarization in those cases may be appropriate. But again, it depends on the type of document. But I would not favor complete elimination of notary requirements, especially for really important documents like wills and things like that.
Okay. Scott asks, what can Congress do to get FAA approval for a Boeing 737 MAX?
What can Congress do to get FAA approval for the Boeing 737 MAX? Well, that's an interesting question, because there you're usually talking about the FAA applying, technical standards to an aircraft. And I would say Congress would be unlikely to intervene and say, compel the FAA for political reasons. Obviously, there are many in the aircraft industry who'd like to see things move along there quickly. But for Congress to intervene and say, you approve it regardless of what your technical standards say or regardless of what your procedure is. So I doubt Congress is likely to do anything to try to push the FAA. And I understand, where that hesitation comes from, because the idea is that the approval shouldn't be a politically driven process. It should be purely based on the technical requirements.
We're waiting for more answers.
Okay. Well, thank you, Molly. You've done a great job, and we've been going here for 45 minutes, so there's no need for people to scour the list of potential questions. But I encourage everyone to keep on watching. We'll be doing these as long as the virtual campaign is in place. And for those of you who are wondering when the campaign is going to go back to looking like a normal campaign, the answer is soon. I can tell you that the Republican Party of Kansas is in the process of scheduling the second senatorial debate, and it looks like it's going to be Saturday, May 23rd in Manhattan. So hopefully by the second half of this month, campaigning will start to look like it used to look like, and we will have in-person events. We will certainly post information about that debate, depending on how big the venue is, how many people can be there.
watch it live. We will encourage you to do that. I'm hoping that sometime before the end of the summer, we have parades going again. But regardless, we will be doing campaign events with the Kobach Senate campaign. So I'll be traveling around the state. I would anticipate starting very soon. And as soon as the safety level is appropriate and it makes for safe campaigning and safe interaction with people. But I would anticipate that very soon we're coming to your town, and would encourage you to contact us if there's an event or something that you'd like to see me at. And we will also be renewing the Con Law 101, the Constitution 101 courses in person. And we had a number of those scheduled throughout the state. We'd done half a dozen already, but we will continue doing those in the months ahead too. So I look forward to seeing people in person. And as much fun as these Facebook Lives are, they're not nearly as good as actually being there with you, answering your questions in person. So everybody stay safe and God bless. Thank you.
Oh, wait, there's one more question.
Okay, one more question.
Okay. What should voters know about you that they don't know already?
What should they know about me?
That they don't already know.
That's an interesting question. Well, you tell me, Molly. What do you think people should know about me that they don't know? I'm putting Molly on the spot here.
That you're gonna do what you say you're gonna do, and you're very conservative, and
they probably know that.
Yeah, I think they should. In case they don't know you, yeah, and that they should vote for you.
Well, thank you, Molly. I appreciate that. No, what Molly said is about me doing what I say I'm going to do is pretty important. I try to live my life that way and to imprint that upon my family, my kids, that, your yes should mean yes and your no should mean no, to put it in scriptural terms. And that's important in politics too. I think we need to live our lives honest with people, and people in politics need to be very honest with voters and say exactly, if there might be a question I get about some policy I've never heard of, and then you can't say yes or no. Your answer might be, well, let me find out and I'll tell you. But voters need to know what you stand for, and voters need to know what you're going to do. And I think people who've watched me in my career as Secretary of State and in the other things I've been doing in my life, I think it's important to tell people exactly where you stand. And that's why sometimes people in the press and people in politics will say, oh, Kobach, he's really conservative. No, I'm just consistently conservative. I don't say one thing in the primary and then suddenly pivot in the general and act like a completely different politician. I tell the truth all the way along. And that way, if voters see what I think, and they know that I'm going to fight for what I say I'm going to fight for, regardless of who's listening or regardless of who's watching. I think honesty in politics is just as important as honesty in a family and honesty between people. So good point, Molly.
Okay.
All right. Now are we done?
Yeah.
Okay. All right, everybody. God bless and stay safe. We'll see you next time.